It's terrific to be back with all of you. May 2nd, gosh, we're in May, amazing. And it is sunny here in New York City. We're going to be focusing on New York City today in interesting ways, not on the law itself, but who's presenting. We have a full New York City lineup, which I think is the first that we've seen here on the Business in 23 program. I'll be going through my introductory remarks, and if we can go to the agenda slide, Kathy, let me introduce the group to who else will be here with us. I'll also, of course, touch on the New York State and New York City budgets as typically a space I cover for all of you. And believe it or not, we are getting nearer to what is expected to be the end of the public health emergency. That's slated for May 11th. And so I'll touch on some of that too. Thereafter, Corinne Tierney, who sits around the corner from me, will be touching on New York City standards around artificial intelligence. We've spent some time on this program talking about AI previously, and this is a deeper dive in terms of some of the hiring practices that may be affected by local law 144, which could very well have implications for other jurisdictions and is, in our view, worth your time to learn a bit more about. Liz Heifetz, who also sits nearby me here in New York City, is an immigration attorney. And Liz does a significant amount of pro bono work. And we thought it would be great to give the audience a sense of Bond's commitment to the community and the ways in which we are able to help individuals facing challenging circumstances. And Liz will give you more insight in terms of exactly what that looks like. Paige Carey is also here in the New York City office, essentially on the other side of the floor from me here. And she is an attorney focused on education law and is going to be looking at the public health emergency in a complement to my presentation, really focusing on the higher education implications. So with that, let me get started with my remarks. And again, just thrilled to have all of you with us. So in terms of New York State on the budget, we've been talking about it for a while. We are a month past when the budget was due, which has not happened in quite a while. But what we learned over the late evening of Thursday last week on the 27th is that Governor Hochul was confident enough that the budget was coming to a place of finality that she made an announcement of a conceptual agreement. And so what we've seen since then is a general sense that the budget negotiations were coming to fruition, but we hadn't seen the bills yet. The bills are actually now out there and circulating, this within the last 24 hours or so. These bills or really the bill is called the Big Ugly, because what it does is take hundreds and hundreds of smaller provisions and rolls them all up into what ultimately will become New York State's budget. And that is currently under consideration by the legislature. It's quite possible that we're going to have approval even while we speak of core elements of the budget. Otherwise, over the next 24 hours, we expect the budget to ultimately be in place for this fiscal year, retroing back to April 1. And so some of the highlights, though, are healthcare provider rates. And, depending on one's perspective, highlight may be, a more or less applicable term. In specific, there are increases in rates for a variety of healthcare providers, whether hospitals or nursing homes or others that we've talked about here in the space. But from the perspective of most of those providers, it is really not enough, particularly in the context of the pandemic. And when offset by some of the other policy pieces in play, for instance, in the home health space, their wage parity standards, and there's this minimum wage increase, which I'll get to in a moment. The actual effect of the increases, in the view of some, is not very robust, and there's been a lot of public statement in that vein. The governor, as well as the legislature, both have gone on the record in various ways talking about how these increases are some of the most substantial we have seen in many years. And so it is very much the case that both evidently are true. But here we are. And so Let me also just focus you on the fact that, with minimum wage, which is, a complicated policy discussion, of course, there is now language that we expect to see finalized and approved again as this budget language all gets signed into law, that will over time push up the minimum wage to $17 in New York City and the surrounding suburban counties down here from where I'm speaking, and then $16 an hour in the rest of the state, all by 2026, and with an element attached to essentially the inflationary peg that we've mentioned here before, where as more data are gleaned in terms of a year-to-year system for wage increases, that's essentially what we expect by way of this budget to see, so that this doesn't get negotiated year in, year out. That's at least the governor's goal, but the language will be important, and we'll tear into it, as it were, as soon as we see it. On cigarettes, taxes are going to go up again, but the governor had really been pushing rather publicly for restrictions on mentholated cigarettes, and those did not pass. On bail reform, that we know was a sticking point for the governor and led to some of the delays and ultimately seeing this budget come to fruition. For the most part, the governor was able to, through negotiation, end up on the side where much of what she proposed is in the budget. There will be greater flexibility afforded to judges in certain circumstances around bail. Supportive housing, though, we mentioned in previous presentations, which I've covered with all of you, and that is out of the budget. That'll be handled separately, whether through working groups or otherwise, we shall see. The MTA, the Metropolitan Transit Authority, for those of you tuning in from the downstate or who come here to visit, it's an important part of the lifeblood of New York City, getting people from place to place, of course, whether subways or otherwise. And the funding of the MTA has been very much in question, a big part of this budget, because the MTA has been under such strain in the context of the pandemic. The solutions are through an increase to the MTA, but there are varying effects on counties, both outside and inside New York City. Plenty of debate about how that's all shaking out. Then finally, last two items I'll mention are funding for migrant resettlement, which is, of course, an ongoing issue that's in the budget. And this is not an immaterial one. Natural gas over time is something that the governor has focused on seeing eliminated in new construction, and there should be language in the final bills that really spells out what that will look like. Next slide, please, Kathy. In New York City, just shifting there, we're not at a point where we have an agreement that is imminent in the same kind of way. The budget there goes into effect for July 1, but we do have Mayor Adams' executive proposal, which recently was just issued with 106.7 billion rolled into it. One of the challenges that the controller, Brad Lander, noted is that it's difficult for New York City's budget to really be assessed until we know what the interweaving state elements of it look like, which is to say, what are New York City's obligations to the state? What can New York City expect to be, seeing in terms of state relating boosts? Now that that dust is settling at the state level, it's expected that the New York City budget negotiations are really going to pick up steam. So more on that in future broadcasts. Next slide, please. So let me turn to the end of the public health emergency, which is the last area that I'm going to cover this morning. And this, of course, could be a 90-minute presentation in and of itself. So I'm just going to be touching on highlights. We know, as I mentioned, that if everything stays according to current trends, in particular with regard to the incidence of COVID in the community, the public health emergency is going to end on the 11th, later this month, coming up fast. And just yesterday, excuse me, on the 1st, there was an announcement by both the Department of Health and Human Services and as well the Department of Homeland Security that vaccination requirements are going to be ultimately lightened for settings like Head Start educators, CMS certified healthcare facilities, and points of entry coming into the United States. All of this is in connection with, of course, the diminishment of COVID in our community, which is a good and positive development. So more on that as that gets sharpened, but thought it would be worth just noting that. Next slide, please. And then I've talked about some of this before with the Medicare and Medicaid programs, but let me just remind you, as the PHE winds down, for the most part, the government payer programs are going to continue to make available COVID treatments, vaccination, and the Medicaid program, Medicare program, excuse me, will also remain on the table without, a sense of financial responsibility for those in the program that will feel appreciably different from the PHE. Nursing homes, this has been an important part of what the pandemic has been about. Of course, there were changes in terms of how individuals moved into nursing homes, relaxation specifically in terms of the pathway between hospitals and nursing homes. The standard had been, generally speaking, that someone, in order to be eligible for essentially a reimbursed stay at a nursing home, needed to be at a hospital for 3 days before that in order for that eligibility to kick in. That was waived during the pandemic, which really allowed for much freer movement. That standard is going to come back. We don't know exactly what Congress may or may not do to seek its change overall later on, but for now, we're going back to 2019, as it were, with regard to that standard. I mentioned that with telehealth, and this I talked about previously, the Medicare program is extended essentially through the end of 24 because of the Consolidated Appropriations Act of 23, which tackled that piece. And then with Medicaid, what you're going to see state by state are differences in terms of the local applications. So more on that as we see it rolled out. Next slide, please, Kathy. We also know that the CDC has gone on the record to indicate that, in terms of community tracking of COVID data, we're at a point where no longer is it going to have that kind of elevated importance for the agency. And the touch points will be, essentially proxies. Hospitalizations are going to be the key measure for the CDC. We can expect that's going to have emanating consequences across the country, including for local state collection patterns and requirements of healthcare providers. More on that as we move into a more formal position there, but that's something else to watch, and we'll keep all of you updated. So why don't we go to the next slide, please, Kathy? And with that, I'm delighted to wind up my comments for this morning, or this afternoon, excuse me, if you're here on the East Coast, and then introduce you to Corinne Tierney. Corinne is an associate with our firm who focuses on employment and who has been, in particular, someone who's been closely tracking artificial intelligence standards. And so what I think will be important for all of you to know is that there are changes in the law in New York City that relate to hiring practices. And while not everyone tuning in here is, in New York City, we know that well, there's plenty that we think is worth your while, just so you see the patterns and are better understanding of some of the ways that AI may be applied. We've been talking about AI here on the program now for a number of different segments over a number of different programs that we've aired, and we just want to keep up that focus because we think it's important for all of you. With that, Corinne, I want to cede the floor to you. I thank you very much for taking the time to present, and please let us know what's going on. Thank you.
Yeah, all right. Hi, everyone. My name is Corinne Tierney. As Gabe mentioned, I'm here in the New York City office, and I'm going to discuss some developments to Local Law 144, which, to be clear, doesn't really, as Gabe kind of hinted, it doesn't really matter where the employer sits. What really matters is that this law is designed to protect New York City resident applicants. So it's really where the applicants are that really matters, which is why it can apply across jurisdictions. So let's just get started. Kathy, can I get the next slide? All right, so Local Law 144 was introduced, I want to say in like 2021. It is officially effective as of, it's effective right now. It was effective as of January 1st of this year, but it won't be enforced until July 5th. So there's a little bit of time to catch up in the event that you're not sure if your company is particularly compliant with this law just yet. So you might want to mark your calendars for that date. basically, this law is designed to regulate the use of automated employment decision tools. I'm going to refer to that generally as AEDTs, which is how the law also refers to them, which does include the use of artificial intelligence, such as, platforms and different, well, we'll get into it. The definition is actually a bit finicky. Really, it's about AEDTs when they're used specifically in decision-making for hiring and promoting of New York City resident applicants. So just to be clear, this is not a general AI law. It's not designed to regulate the use of artificial intelligence pretty much in any other setting. It's really specifically for artificial intelligence that is used in the hiring or promoting of candidates. The purpose is really just to ensure transparency in the usage of AI as it pertains to employment decision-making, so as to avoid any discriminatory effects, whether or not they be intentional. That's really the point of this law. And you're gonna see laws like this come out all over the country. You'll see it come out in the state. You'll see some, I believe Europe is actually coming out with some regulations similar to this as well. So we'll see this continue to develop over time. Kathy, can I get the next slide? Thank you. So this one I'm going to read. This is the definition of AEDT. So this top part is the actual definition in the original law that was drafted. Basically, it's defined as any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, including a score, classification, or recommendation, that is used to substantially assist or replace discretionary decision-making for making employment decisions that impact natural persons. Now, on April 6th of this year, the Department of Consumer and Worker Protection, the DCWP, they came out with they adopted a much more narrow definition of what an AEDT is. That's below here, so I'm going to read that as well. Basically, it states that the law really only applies to a tool if the tool is the sole factor in an employment decision, 2, one of several factors, but more heavily weighted than other factors, or 3, used to overrule. Again, just clarifying, not modify, but used to overrule conclusions derived from other factors, such as human decision making. So this is a very complicated definition, and it's not 100% clear how the department or any court would really determine which tool qualifies under this specific, arguably very narrow rule. So you will want to sit down with your employment attorney and determine whether or not your usage of any AI or a certain kind of platform, as it's used in hiring and promoting candidates, you might want to sit down with an attorney just to see how this analysis actually plays out, because it's probably going to be very different for employers and employment agencies all over. Kathy, next slide, please. So basically, some simple highlights to the law is that you can't really use the AEDT if it has not been subject to a bias audit within the last year. So practically the way this is going to play out is that if the tool that an employer or an employment agency is using qualifies under this law, you're effectively going to need an annual bias audit, and it needs to be independent. We'll dig into that a little bit later, but that's just something to be very well aware of. It's probably going to be an annual audit. The second thing is, under the law, you're going to need a summary of the results, including the date of those results. That is the date of the most recent bias audit, and its distribution data, including the selection rates, impact ratios for protected characteristics. And they need to be made publicly available on the employer or employment agency's website. That's actually kind of nicely spelled out in the law. So you can refer to that if you have any questions about where it needs to be placed. The Department of Consumer and Worker Protection is pretty good about specifying that. So Kathy, can I get the next slide? Thank you. So below are some additional highlights to the regulation. I'll let you guys look at these in your own time, but really, again, I do want to highlight the bias auditor. So the rules that are designed to support the original law define a bias auditor with multiple, I think it's 5 disqualifying characteristics. In order for that person or that entity to provide the employer or employment agency with the right bias audit, really, the department is looking for someone completely independent, which means even the vendor, the person, the agency, the entity that creates the tool that an employer or an employment agency is using, They can't even do their own bias audit. The employer can't do their own bias audit. It needs to be done by an independent third party. Like, that's just the way the law is designed. So again, some of those disqualifying characteristics are written in the rules. So feel free to look at that. And below are a couple of additional definitions with respect to, let's just say hypothetically, you've never used a tool before today. Let's just say hypothetically, what data can you provide by July 5th? The below kind of spells out and teases what an employer or employment agency might be able to use in lieu of that. For example, you can use historical data, you can use test data, depending on what you have available. So I'll let you guys kind of read those definitions, but they're really for people who don't have enough data to provide in their disclosure, in their summaries. That would be subject to the bias audit. So Kathy, next slide, please. The published notice of the audit. So yeah, the public notice posting requirement, it can be, met, as I said before, with an active hyperlink to the website of the employer or employment agency, which, as again, you wanted to have a summary of the results and a distribution date of those results, but the link does need to be clearly identified. So that's something else to keep in mind. The summary, I don't think I'll go in over really briefly. The summary includes data of the most recent bias audit, summary of its results, score and explanation of the data used to conduct the bias audit, the number of individuals that the AEDT assessed that fall within an unknown category, the number of applicants or candidates, selection, scoring rates, as and really if applicable, it really depends on how you're using the tool. And of course, the impact ratios for all the categories that I believe are I believe it's the categories that are named by the EEOC. So most employment attorneys will be aware of which protected categories that actually is. And again, the distribution date of the AEDT, even though, again, you're going to have to do this on an annual basis. It's every year. So if you got that audit done on January 1st of 2023, you actually can't use those results anymore on January 2nd of 2024. It has to be done like every 365 days. It's going to be an annual thing. So Kathy, can I get the next slide, please? Thank you. This is another big part of the law. So other than the transparency, the disclosure of the summary of the results and distribution date of the bias audit for the tool, there's another requirement that employers and employment agencies need to really be aware of. So you're supposed to actually formally send a notice to a New York City resident candidate or applicant at least 10 business days before an employer or employment agency actually uses that tool at all. So that might cause a bit of a lag, but that's ingrained in the law. There's really no loophole for that one that I'm remotely aware of. So basically, an automated employment decision tool, you'll want to tell them that it'll be used to assess the candidate. You also need to inform the candidate the job qualifications and characteristics that the tool will use in that assessment. And you also need, the employer or employment agency needs to allow the candidate or employee to request an alternative process and recommendation. But under the notice of adoption of rules, no such alternative process is actually required to be provided. So that's an interesting aspect, but you still need to inform the candidate how they can go about requesting such alternative process or accommodation. All right, Kathy, next slide, please. Yeah, so finally, last thing, so penalties, I'll go over this briefly. A civil penalty will be really up to $500 for the first violation, and for each additional violation occurring on the same day as the first violation. It can be $500 to up to $1,500 for each subsequent violation. So that'll pretty much be like the second day. If you're not compliant for a week, the second, third, fourth, fifth, sixth, and seventh days can be upwards of $1,500. So that can really accumulate quickly. You really want to make sure that you're being compliant with this law as quickly as possible before July 5th. And last thing is it will be enforceable by the New York City Corporation Council, and a complaint can be filed with the Office of Administrative Trials and Hearings or with the Department of Consumer and Worker Protection, and also presumptively the New York City Commission on Human Rights. Presumptively, they will also have the ability to enforce this as it does pertain to discrimination in employment. So that's all that I've got on this law. Thank you. If you have any questions, please, definitely want to reach out to an employment attorney that you trust, because This law is very technical and very new, but again, it will be expanding rapidly around the state and around the country. So good to be aware of it and get ahead of it. Thank you.
Corinne, thank you so much for taking the time. Looks like you have some questions in the chat as well for you. And let me, before introducing Liz, which I'm excited to do in just a moment, circle back to my presentation. I received a variety of questions in the chat concerning COVID sick leave in New York State. I didn't highlight it. Paige will actually be addressing it as well. But the long story short, it remains in place until there's legislative action to change it. We shall see if there is anything like that. We've been tracking it. We know it's a complex operation, as it were, for all of those employers here to stay on top of. And so if there are changes, we will make sure that you know of them. Nothing with the wind down of the PHE specifically affects that, though. So why don't we then move to our next slide, please, Kathy, and we can introduce Liz, who is, more formally Liz Heifetz, who is an associate with our firm. And Liz is someone who focuses throughout her practice on immigration law, helping a variety of businesses that engage, bond. But a big part of where Liz also practices and focuses her energies is on the ways in which bond can be helpful in the community where there are immigration challenges for individuals who with bond's help can have more stable futures and pathways. And so Liz is going to give you a little inkling into what that community-oriented work looks like. And so Liz, I look forward to learning more about it, and thank you very much for taking this time.
Thanks, Gabe. Good morning, everyone, or good afternoon, depending on where you are. So as Gabe said, I'm an immigration attorney here at Bond. I do predominantly corporate-based immigration, businesses, large companies across a variety of industries. But my pro bono work predominantly focuses on humanitarian relief cases. And so kind of what I wanted to talk about today in our presentation was give you kind of an idea overview of the kind of cases that I've been working on, the kind of cases that, I want to provide, to the community to see if anybody wants to kind of assist, engage, give you an understanding of what's kind of going on and provide kind of an update to reflect the kind of work that we've been doing generally across the immigration community. So with that, Kathy, can I get the next slide, please? Thanks. So like I said, most of the work that I do pro bono is humanitarian relief, and specifically I focused on humanitarian parole application and affirmative asylum applications. I wanted to give you a brief overview what they are in just a couple words because you may or may not be familiar with them. But for humanitarian parole applications, these are essentially a discretionary grant of temporary permission to enter the U.S. for an urgent humanitarian reason or significant public benefits. The misconception here is there is no immigrant status here. There's no pathway to permanent residence. There is no visa. This is not a substitute for a visa. There's no citizenship guarantee here. This is just an escape from a dire situation. These cases, there's a very high threshold to meet them. They rarely ever approved. And to that degree, as a result of that, now it's become country specific because some countries have been recognized, such as most recently Ukraine, and before that, Afghanistan, Cuba, Nicaragua, and Venezuela. And so that is something that is a very high threshold to meet, but if you can't meet it, there's potentially alternatives that we can kind of help with the community. For humanitarian parole, the case I recently worked on was for a little boy from Ukraine. After, all the violence broke out, he was left kind of all by himself. He had an aunt in the US, needed to get here somehow. We had no documents, no passport. It was a very, bad situation. He had to cross 3 countries on foot through a bus. We filed this application for him. He is in the US right now. He is with the aunt. He's doing well. They're trying to adopt him now. So I love stories that end well. Kind of the reason I wanted to start doing pro bono immigration work here. And so that case ended well. They all don't end that way. The other 2 cases that I'm working on are both affirmative asylum cases. As a brief overview, just really quickly, affirmative asylum is just those cases where you have yet to be deported. So you can apply after you've been physically present in the US for about a year. and you meet the grounds for asylum, which I'll get to in 1 second. And defensive asylum is essentially you're on the train to get deported and you have to go to immigration court to defend. The two different avenues, two sets of audiences, different things you're kind of triggering. But overall, the grounds for asylum are essentially you have to show fear of past persecution or future persecution on the grounds of race, religion, nationality, political opinion, or particular social group. That last one, subject to interpretation, this always changes. There was a case that was passed down years ago, matter of Acosta, that essentially said how we define this is a group that shares inimmutable characteristics and fundamental traits, kinship, sex, color, certain past experiences. Recently, FGM, female genital mutilation, has risen to become a recognized PSG. And so as is gang violence as well. Other than that, other cases, it's just a case-by-case basis. And so the cases that I worked on here was an FGM case, was a woman from Western Africa that was fleeing and trying to prevent her daughter from being kidnapped and being exposed to female genital mutilation in their home village in Africa. So that's a case that's currently pending. They take a very long time. We will see what happens. That case was a little bit hard because it's hard to, kind of find the proper supporting documentation. This FGM is also subject to the Convention Against Torture. So there is, kind of a double filing component there. We'll see. This is all very discretionary at the end of the day. The other one, similarly, this is about another case from Haiti, a gentleman in a very high profile position in the government. Also, we can file on two grounds for him: political opinion and particular social group, because of the particular Haitian gang violence that is happening in that little village. So it's very interesting cases. Asylum takes a very, very long time to get approved. Right now, according to the Buddhism's report in 2022, I think there are right now over 430,000 affirmative asylum applications pending, just affirmative. In the immigration court, with regards to defensive asylum cases, there's over 2.1 million cases. And overall, it takes about 4.2 years to even get a case approved. So it takes a very long time and it's very, very hard. As a side note, just to give you an idea how sometimes this immigration humanitarian field kind of factors into the corporate structure that I work with some organizations, is I actually have a client from a big company who previously filed an asylum application. He is here, he's lawfully present, he's lawfully working pursuant to an EAD, but he was recently selected in the H-1B cap lottery, which is a randomized lottery in order to be able to apply for an H-1B visa, which is a very highly sought after visa because it has dual intent, both for temporary employment and provides a path to citizenship down the line. But the only two ways to apply for it are change of status versus consular processing. And in order to apply for a change of status, you need to first have a lawful status. And lawful presence and lawful status are not the same. And so his application is still pending. It will be difficult to apply for that. We're still going to do it. We're going to make an unprecedented argument here with why he qualifies and see what happens. And if that, if all fails, there's consular processing, which is going to have its own set of issues because as an asylee, he can't go to his home country to activate the H-1B visa. He doesn't have a valid passport. There's third country rules for processing. So this is going to be a complex situation, but at the same time, very, very interesting. And also kind of shows you that sometimes cases within the humanitarian scope bleed into the kind of the employment-based work that we do as well. So that's just kind of one example that just pops into my mind. And with that, I kind of want to talk about the most recent update that's coming up that you're going to be seeing, you're going to be hearing about. Just give you a brief overview of that. Kathy, can I get the next slide, please? Thanks. So you may or may not have heard of this. I mean, Title 42, this was the public health order that was set out a couple years ago. This was done that essentially allowed border authorities to expel migrants without processing them for asylum on COVID-related grounds. On May 11th, that's going to be terminated essentially. So naturally, you would expect this to lead to a lot of migrants crossing over. Some statistics recently showed it would be about 18,000 or so. So what's going to happen here? What does this mean for us? Kind of, you're going to hear about this. You're going to see this in the news. It's going to be a thing in the next couple of months. what this is going to happen, what's going to happen is this. So they're going to terminate this. They're going to, expedite removal proceedings as needed. If they're going to be expedited, the reentry bar is 5 years. That's going to stay the same. The new measure that's being taken with this rescission is the implementation of the rebuttable presumption of ineligibility for asylum. That part was not present in Title 42 when it came out a couple years ago. And this essentially means that, so you cannot, an alien entering the country would be ineligible for asylum unless, number one, he or she receives parole in their home country, which, going back to our earlier conversation about humanitarian parole, this takes 10 plus months, high threshold, and sometimes circumstances are dire and it's impossible to get, but that's going to be one of the exceptions. You would have to show that you've received parole approval. The other one would be, you would have to present yourself at a port of entry through a pre-scheduled time and place. There's a CBP-1 mobile app that they're going to institute, and they're going to try to get that to work, and people are going to have to figure out how to use that in order to be able to abide by this law. Or the third one is they're going to have to show that they were denied asylum in a third country on their way to the US. So we'll see what comes of this. There are going to be challenges with this because the CBP internet-based scheduling system has a lot of flaws. It's not foolproof yet. It's going to cause a lot of kind of ambiguity also, because when something new comes out, it's just inevitable. There will be safeguards to kind of account for this newness, but those safeguards are also kind of going to be complex. So, for instance, with this, the requirement that you need to use the CBP-1 mobile app in order to be able to schedule your appearance. The exception to that kind of will be you can manage access port of entry, but you need to demonstrate by the preponderance of the evidence that it's not possible to use this app, either through illiteracy or significant technical failure, ongoing, so on and so forth. And so it's going to be hard, especially for pro se asylum seekers. And obviously, they will not be able to make the proper or the complex enough argument at the time necessary. So we'll see what comes of it. Time will tell. We'll just have to wait and see. And Kathy, can I get my last slide, please? And so just in general, like opportunities available, what can be done. Affirmative asylum, humanitarian parole are not the only cases that can be worked on. If you're interested in learning more about temporary protected status, individual juvenile status, that's also a fascinating set of case law, U visas, WAVAs. There's a lot to get engaged in. You don't have to be an attorney, attorneys, non-attorneys, anything is possible. Immigration in this sense is very technical, very nuanced, a lot of room for creativity, translations. The world is your oyster kind of thing here. So I could go on and on and on forever, but if you have any questions, if you know anybody that you want to kind of send through, if you're curious yourself, if you just want to chat anything, please reach out to me. I'm happy to chat for as long as you want, answer any questions. And yeah, we can, see what happens in the coming weeks, because immigration always changes, always on a day-to-day. So there's always things to talk about. Anyway, thanks so much.
Liz, thank you. That was really very helpful to give some sense of the casework that you're involved in and its connections to the employers that we represent. And we look forward to having you back on a future program. I want to introduce our final speaker for the afternoon, who is Paige Carey. And Paige is an attorney who focuses on the intersection of labor and employment and education. And who better to tell us a little bit more about, with the public health emergency winding down, what institutions of higher education should really be thinking about. So Paige, the floor is yours. We really look forward to learning from you, and thank you for taking this time.
Thank you, Gabe.
Paige, I think, oh, there you are.
Sorry, I don't know what happened. Thank you, Gabe. Hi, everyone. Kathy, can you please go to the next slide? So I'm going to jump right in. I know we're running a little bit short on time, but just as a bit of background, 2 major federal updates are important to keep in mind throughout this presentation. On April 10th, President Biden signed a bill into law terminating the COVID-19 national emergency, and that was effective immediately. And then, as Gabe mentioned, May 11th is the planned end date for the end of the public health emergency. So how do these updates impact institutions of higher education going forward and employees generally? Kathy, can you please go to the next slide? So first major point to keep in mind, and I think this will relate to a lot of the questions that were in the chat, and this is very important for all employers, not just IAGs. But the two key laws in New York regarding COVID-19 are still going to be in effect. The emergency law mandating 5 days of paid sick leave for individuals with quarantine orders is still in effect because there is no end date or trigger provision specified in that law. So we're still waiting on an update there. And additionally, employers must still provide employees with up to 4 hours of paid leave to obtain a COVID-19 vaccination until this law's expiration on December 31st, 2023. So that one does have an end date to keep in mind. Kathy, please, could you go to the next slide? So important considerations for employers and institutions of higher education. These laws are very critical to keep in the back of your mind regarding employment considerations generally, and also COVID-19 policies. Practically speaking, to receive 5 days of paid sick leave, individuals need to obtain a COVID order. With the end of the public health emergency and the end of the national emergency, this may become increasingly difficult to do so. So we could see this phasing out. Also, as of now, as I mentioned, December 31st, 2023 is the end date for employers required to provide a 4-hour paid leave for a COVID vaccine. Next slide, please. So this slide gets a little bit more specific to higher education institutions. So the special provisions adding additional eligibility for students to obtain SNAP benefits are going to be phased out with the end of the PHE. Per the guidance released by the USDA on February 10th of 2023, once the public health emergency declaration is lifted, which will be the planned date of May 11th, the temporary student exemptions that were in place during the pandemic will remain in effect for 30 days for the SNAP benefits. So you have 30 days following the end of the public health emergency on May 11th. And Gabe mentioned this as well, but Medicaid is also something to keep in mind. There will be some loss of insurance due to phasing out of Medicaid expansions. That's definitely a very broad topic in itself, but just felt it was important to mention that briefly. Next slide, please. So what this means for institutions of higher education is it's important to conduct immediate and targeted outreach to students that may be phased out of SNAP benefits that they were able to get temporarily during the pandemic, specifically because there is that 30-day time period following May 11th for which those exemptions will still apply. And one thing that can be done is to prioritize outreach through use of FAFSA data and administrative data. However, it is important to keep compliance considerations in the back of mind when doing so. There are provisions in FERPA that must be followed first before conducting this outreach. Next slide, please. Another important consideration is the phasing out of COVID-19 testing. So pre-May, not phasing out of COVID-19 testing, but it's going to be integrated into more of a traditional healthcare model. So phase out of the COVID-19 specific regulations for testing. So before May 11th, which is, as I mentioned, the end of the public health emergency, the PHE mandated that health insurance plans fully cover COVID-19 testing without employee cost sharing on both an in and out of network basis. However, after May 11th, medical plans will not have to pay for the testing, so it will become very plan dependent. Next slide, please. So what this will mean for institutions of higher education is There will be a phase out of free on-campus testing. This will likely occur as the free vaccination testing kits become less available because they're no longer in the budget that has been provided. And because this is more of a phase out and it's more based on availability, there's not a definitive date for this end, but something to keep in mind. And there is going to be a movement towards a more traditional healthcare model, as I mentioned, that will be aimed towards curing COVID. So what this means is insurance is going to play a much larger role, obviously, because that is more along the lines of a traditional model. So that is just a little bit of a brief update and a couple of points covered regarding employers generally in New York and also institutions of higher education and things to keep in mind with this phasing out of the end of the public health emergency and the end of the national emergency. If you have any questions about these points, please feel free to reach out to me or any other bond attorney or any employment attorney generally. Thank you.
Thank you so much, Paige. That was very informative. It gives the group some high-level considerations to take away. And Paige, as we move into an environment where the post-May 11th details begin to get fleshed out all the more, you're welcome back so that we can dive in all the more deeply. So Kathy, if you go to the next slide, please. I want to just make sure that the group has an opportunity to as we walk away from today's presentation, remember that Bond continues to offer its annual labor, employment, and human resources conference, its Workplace 2023. We have begun the series. The dates that remain available are here on this slide, and we look forward to having you sign up and join us wherever it's most geographically convenient for you. And in the interim, I want to wish all of you a terrific afternoon. If you want to contact any of us who's presented today, you've got it there. And looking forward to being back with you later this month. The next program will be with our group on May 9th. And I, for the moment, look forward to being back with you later in May. So have a terrific day.